actually against your claims. And then you have that of the design patent. So I
info to look up and research.
And yeah, well, one thing to add to that is, and I think Ms. Carter can recall back to her examiner days. Is they're gonna typically, the way patent examination works is you go in with some claims, and then the patent office asks you to narrow those claims, because a strong patent is a broad patent, because you want to exclude as many people as possible. So when they push back on you, they want you to narrow, and typically the way to narrow your claims is to add more structural features. So when it comes to things that you carve out of wood, or a medical device, or some sort, a tangible item, you can pull, as long as you kind of described it all accurately, which that's where we come in. As long as you describe it accurately, you have all these different levels of structural features you can add to your claims to circumvent the prior art. And as you might imagine, with software, there isn't as much structural features to pull from. So you need to, as you're drafting that application, specifically the claims, you need to be thinking about, okay, what are these different aspects that I can write to be kind of like the structure of the software. That doesn't necessarily mean the source code or the behind the scenes code. You usually don't want to publish that stuff. You gotta consider that whatever you put in your patent application, most likely, and there's some rare cases that it doesn't, but most likely it'll get published. So you have to be ready for that. So that's another thing you got to kind of think about is in a lot of ways to add structure to software claims is tying into connecting the software with the actual functional output. What is actually being done? And if you can, if you're okay with limiting your claims with that gives you a good route to patentability. And I do gotta hop off now. If you guys are still talking in a bit, I'll try to jump back on. But I do have two pretty good YouTube videos on YouTube. If you just kind of Google my name or search my name, Maysam Pessian, there's one good 45-minute talk on filing considerations for your IP, and then another about hour talk that talks about the differences between patentability and freedom to operate, two terms that Ms. Carter brought up earlier. They're similar, but actually very different. And my contact information is going to be on those PowerPoints. So I encourage everyone in the audience, if you're interested in filing IP, definitely consult Ms. Carter, consult everyone on this panel, but take a look at those videos too. They're quite helpful. And thanks a lot, Jonathan, for having me. I'll try to catch up with everyone later. Thank you.
Thank you. You offer such great insight. So thank you so much.
Oh, thank you both.
And Jason, I would just say, as a founder, and particularly a founder of a hardware company, the roadmap that they just gave it could not be more spot on. So I'm sitting here smiling as a founder who has a hardware company with a software component to it. But if you're thinking about real hardware, those nuances to your hardware, what it will look like, the design, all of that becomes incredibly important when you're thinking about the patent process.
Good to know. Thank you.
So, Jason, I would also like to chime in if I could. I am not an attorney. I am a CPA by trade. I'm a serial entrepreneur. I have a couple of issued patents. I would love to just take a step back, because sometimes patents are not always the way to go. If it's speed to market, and if it's something that's not patentable, sometimes maintaining a trade secret, which is what we did with our third technology, is we are not disclosing it. And there are a lot of other things to consider, especially when you're filing a patent. There's a window for international filings for PCT, which you can file in Europe and you can file in Canada and Australia. And I would like to tell you a little bit about the mistake that we made. We had two patents, and on the second one, we decided to do the PCT. and there were a few days in between the filing of the PCT and the second patent, and somebody actually published something about our technology. So it completely voided our previous patents, and it kicked out all our international patents as prior art. So I think the timing, if you could talk about the timing of things. Also, I think the difference between U.S. patents and international, I'm not sure if they publish all the U.S. patents, which means your information isn't always out there. So there are a lot of considerations, and it's very costly. And you can oftentimes find a search firm that can actually do a great search for a lot cheaper than an attorney. So that's all I wanted to chime in.
Thank you, Stella. Thank you very much.
Thank you. That was a great insight as well, and especially on an experience standpoint. I appreciate that. And to those in the audience, you would definitely appreciate that insight as well, because that time piece is very important. In the U.S. and only in the U.S., you're permitted, they allow you at least 1 year, well, I don't say 1 year, I say 11 months of having your idea, concept, and or product out into the market before filing a patent. In other countries, however, that is not the case. And so you must be extremely cautious and very aware of what you're putting out into the public. What are you disclosing to the public? Within what time frame do you intend to patent? If you don't intend, then it's no problem. If you do intend, be very mindful, because the clock starts the minute you allow the public to view your proprietary idea and or concept. So thank you, Stella. That was a great thing to bring up, and especially the idea of utilizing, as a previous patent examiner, I did utilize companies or inventors' previous or prior art against them. So if they had something in the public and they were filing a new application, and somehow it became what is called well-known in the art, I did tend to use that against them. So that is some great nuggets Ms. Stella did share. Thank you so much.
Thank you. You know, I have to say that we didn't find out about this publishing until after, you can file, and I think I'll let you explain what a PCT is, because it makes it very affordable to file in the EU and on different continents. But we had no idea that this one person wrote this little article. This is how important it is not to share or disseminate any information that you intend to patent. And he did one small article, and it was deemed as prior art. And it kicked out all our international patents, because we had our first patent, and then we had our second one, and then he published in between the first and the second one, and it was deemed as prior art, and it was kicked out. So you have to be very careful about what you put out there publicly if you intend to patent it. Even the smallest thing can result in having your patent kicked out.
Absolutely. Thank you for sharing that. And just to piggyback, and then we'll move to the, thank you guys for waiting so patiently for your question. And I guess you are next, Stella. So I'm going to just piggyback on that and just give a definition on the PCT. It is the Patent Cooperation Treaty. It is an international patent. What this particular patent does, if and then it is your business strategy to have a global product and or concept, then this is typically a route to go. The international patent, or the PCT, would be your umbrella, if you will. And so it would be considered an international patent, and then you have a period of time in which you identify designated countries in which you would like to file a patent application in. So if you know, for example, that you would like your product and or idea to be covered in Europe, Germany, Denmark, Sweden, and maybe China, underneath the purpose of the international patent is so that you can stick with the same structure and then have coverage or spin out an application in each of those countries within a particular time frame. And so if and then you do not meet that time frame, however, all bets is off and you will not be able to file underneath the PCT in those designated countries. And so that is also part of a strategy to be very certain that that is what your intent of your product and or idea is, to be a global or to go into specific markets in other countries. Then that should be a conversation amongst your team to decide what is more prevalent. You do have to pay, however, a fee based on each country's filing to their particular register office. And so you would spin out, say, an application for the U.S., one for the Europe, one for Germany, or one for Denmark and Sweden, per se. And that's how that would go. So that's just a broad explanation of a PCT. Thank you, Stella, for bringing that up. And we'll move right on to you. What question or concerns do you may have that you want to ask the panel? And thank you so much for sharing your experience.
I think I'm all set. You pretty much covered everything that I was going to ask you. Thank you so much.
Very good. Thank you. Jonathan, I just totally hijack your role right now. So at any time you want to come in.
You better know your role. No, I'm just kidding. You're doing amazing. No, I want you to keep hijacking. Keep hijacking because I'm just doing things around the house. So you're crushing it.
Awesome. I'll just keep it going. Okay, so you're going to have to help me with the names, keep up with your, let's see. Next, can you please pronounce your name? I will chop it up. I will chop the name up.
No worries, Miss Carter. It's Siamak.
Siamak. Awesome.
Thanks for the opportunity, but no worries there. I have a firm which we perform prior art search, and particularly we've been working with startups and VCs and investors for the past couple of years. One thing that you mentioned, as well as Stella, which we've seen it quite frequently, especially with startup, that they, prior to filing for any provisional, prior to do anything, they go and brag about the product online on their Instagram page, Facebook page, Twitter, you name it. On academic side, they may publish a few papers, but I think tech offices at universities are pretty good about it, educating professors and all the students. But with startups, they go and brag about it, put the entire product, disclose everything online, put videos, even they provide YouTube videos. And those can be used, and they will get used against them once the examiner at the patent office is examining, because they haven't filed any provisional. So one thing that we talk to startups and tell them, do not put anything out there to the world prior to doing any filing or anything like that. Just, you don't really do it. But I think it's a good advice to many of them that I think they get really excited about their product and they want to talk about it and just put it out there. And one funny thing is, once they reach out to any investor or VC, they try to put all these NDAs in front of them and get signatures. However, they're just putting the whole thing out there to the world and show them how things work. So I think you brought up a really good point that especially startups, they need to get educated on those points. I'm Siamak and I'm done speaking.
Thank you so much. You offered so much great insight on that. We often have discussions about that, how important it is to just kind of keep I call it the secret sauce. I did a room on trade secrets, and sometimes it's best to keep things quiet until it's time to pull a trigger. And the provisional patent process or the provisional idea is great. It would be a great way to say, okay, some look at it like, why would I go this route if I don't have intent or I don't know? But sometimes it's worth having that first to file date and that idea protected to a degree, especially if you have intent of trying to share it or get investors or just have conversations about it, or even in the midst of developing it. It is worth that couple of, that financial investment, just to know that one, you're started the process, and two, at least a portion of your concept is being deemed as the first at that moment anyway. Because one thing I want to make it extremely clear to everyone that is oftentimes unclear, it is not, the patenting process is not a guaranteed process. It is not guaranteed that you will obtain the patent you seek. It is all the hopes to gain the patent, but oftentimes I've heard many have been disappointed because of the amount of money they spent or the amount of time they spent, and they were not able to achieve that patent goal. So it all starts with strategy, doing your due diligence, kind of keeping some things to yourself, and executing a plan. It is all about strategy, and then you can be extremely successful in the process. And I will move on because I think I'm jiving with this moderating thing. Okay, so I do not. Okay, next, and who's next?
I think I might be.
Okay, awesome. I think you are. And please share your name with me and the audience and the panel.
My actual name is Joseph. I really appreciate this room. So the reason I hopped in is specifically due to trademarks, and I just had a question that I don't quite understand, and I've talked to my business partner about it. But basically, my question is, I have a newly co-founded startup. We have our operating agreement. It's based out of Florida, so we have the rights to our name, our logo. And we verified that with our lawyers, so we can use our name and logo, but we haven't paid to get it trademarked, so it is not trademarked. And I'm concerned that once we're ready to kind of advertise our name and start sharing it with people, that someone will trademark it and steal it, and then we'll have to pay them to get our trademark. So I just want to, if anybody could tell me how important it is to trademark it, should we just go ahead and do it now? That's really my question.
I would love to just chime in on this one, because we actually, when we first did we entered a competition at MIT, and what we didn't realize is that every single company that entered that competition, well, not every single, but our name, they purchased the website immediately under the name that we pitched. So it is important, because what happens is the second you start telling people about to get you to buy it from them. So, and I did trademark also the name right after that. I think it is critical, if you plan on keeping a logo and you plan on branding that name. And we had to purchase our website at a high price from someone else because we didn't do that initially. That's just my 2 cents.
Okay, and so we already bought the domains, so we have that, but we haven't made our website yet. But can anyone tell me, like, what is it? How much is it to trademark it? Is it like $10,000, like, on average? And like, is it difficult?
I did it myself online.
Okay.
Yes, Lindsay, that's you.
Y'all are causing me a little bit of anxiety over here.
Yes, step right in.
So I've been in the trademark field for over 15 years, so I'm happy to talk to you all about trademarks. So I guess my first question, and this is rhetorical, so I'm not posing this for you to answer at the moment, is what is holding you back? So your trademark is it's your public brand. It's the name of your company. It's what you're gonna take to market. It's really a relatively small investment, especially compared to a patent, for a lifetime of goodwill. And I say it that way because as long as you're using a trademark, you can renew it forever. So it really is a lifetime of goodwill. So the trademark process itself can cost anywhere from $1,500 to north of $3,000, depending on the attorney that you choose to go with. And then you've got government filing fees that are $350 per class. There is a less expensive option, but for argument's sake, we're just going to assume right now that it's $350 a class. And there are 45 different classes. So when you meet with your attorney, they're going to ask you, what you're doing, what your company is doing, what you might be doing now versus what you intend to do in the future. And then they're going to put together an application with a listing of goods or services, depending on if you're selling products or if you're offering services, that fall into one or two or three, whatever it is, of those 45 classes. And when you do that, you're then the application will get filed, and then it will get reviewed by an examining attorney at the trademark office. And right now, that review timeline is between 4 and 5 months. There was a big fee increase at the end of last year, and the trademark office just got completely crushed with applications. So they're running about 4 to 5 months on initial review. So then the examining attorney will review it. You will probably get an office action. And I say it like that because the trademark examining attorneys, the process is somewhat subjective. And so the joke right now, sort of in our trademark circles, is that your office action can depend on what the examining attorney had for breakfast that day. I mean, that's kind of an exaggeration, but we definitely are seeing more office actions than we historically have. And it's not a bad thing to get an office action. It could be as simple as amending your listing of goods or services. If you have a design, it could be tweaking your design. It could be something, if your mark is descriptive of the services that you're providing, you could get something called a descriptiveness refusal. But the first place to start, I know you mentioned that your attorney said that you were clear to use your name. I don't 100% know what that means because that terminology can be used, in many different ways depending on the attorney. But I would 100%, if you haven't already done it, make sure to engage an attorney to do a comprehensive search, especially because you guys have already bought your domain, you're in the startup phase. You want to be sure that there's nobody out there, because one of the hallmarks.
Sorry to interrupt, but I just want to let you know we did do that with our operating agreement. Like that was already checked by the lawyers.
Okay, so because one of the hallmarks of the trademark system is that it is first to use, not necessarily first to file. So even if you have a company and you're using it, somebody, I think you said that you were in Florida, there could be somebody in Nebraska, just to make up something, that is using it as well. And they could come out of the woodwork after you file your application and say, wait a second, we had the mark first. We've been using it for the last 10 years, even though they didn't have their application on file. So that's a really important reason to get your application filed. You did that comprehensive search, which is a great start. And the whole process can optimistically take between 12 and 18 months. It sounds like you're using it or you will be using it shortly. You have to prove use in commerce before you can get a trademark registration. And really it can be, pretty straightforward and not complicated. I hope that answers the question, but let me know if you've got more specific ones. Okay.
Thank you. I'm so glad that I'm so grateful I was able to come here and ask that question because you guys saved me so much time because I would have had to get on Google and make notes and look all this stuff up. So thank you so much for the information. I just had one more question, Lindsay, and that is, we haven't shipped our first app yet, so we're still at 0 assets. But so you're saying I have to actually have revenue of some sort before I can file the trademark? Like we actually have to be in business? Is that what you meant?
Nope, not at all. So you can file something called an intent to use. So if you know that you're intending to offer this product within approximately the next 36 months, you can go ahead and file the application now. You just get to a phase where you're going to have to prove that you are using it in commerce. So if you're going to sell it in the next 36 months, then you'll file something called a statement of use, which says, we are using it. Here's how we're using it. You'll have to submit a specimen. And then here's the date that we first sold it. And so all of that gets filed. And then that's the final hurdle to registration.
Thank you so much. I'm super grateful for the information. I learned a lot. So I'm going to relay that to my business partner and try to give him a nudge to pay for the trademark. So
yeah, it's really no big deal. I mean, I know it can be intimidating, but it really is buying a lifetime of goodwill. I mean, it's no offense to the patent team up here, but it's much less expensive than a patent filing.
Absolutely.
Okay, got it. Thank you so much.
My pleasure.
Lindsay. You always bring it home on the trademark. I love it. I learned so much, even though I'm in a space that is not my expertise, but I love it. Thank you so much. We're going to move on to the next person that has a question. I believe that's you, Zach, if I'm not mistaken. Am I saying it correctly?
Yeah.
Yes.
Cool. Thanks, everyone. My name's Zach Franz. I'm the founder of a company called Wildland Coffee. We put really good coffee into tea bags. So like when you're camping or you're traveling, you don't need to use a French press or a percolator or any other equipment. So my question is, there is a competitor, and the name of this competitor is Steeped Coffee, which, hey, it's a great name because it's very descriptive. And they do have, and I can't remember the exact classification of their trademark, but they did get a trademark on their name, Steeped Coffee. One of the challenges that I'm running into is that they are very aggressive if anyone even uses the word steeped, even descriptively. And so I'm curious, is there anything besides just not using the word steeped, even descriptively, is there anything that I can do that isn't going to cost me an arm and a leg? Because I'm kind of in the MVP stage right now. So, a bunch of legal fees are not, possible at this point, which is kind of what they're trying to do. So yeah, I'm just curious if, what anyone's thoughts are on the situation. Do I just not use the word steeped, or is there something that I could do that would be easy to get them off my back?
So that's a tricky one. I just quickly looked up their registration, and they're on what's called the Supplemental Trademark Register, which it's hard to explain kind of that's not as good as the principal. That's sort of the shortest answer. There are two trademark registers. The principal is the really good one. You have a lot of rights that go with it. And then the supplemental basically acknowledges that your trademark is descriptive. So I guess what I'm not understanding is if your product, by its very nature, is coffee in a tea bag that you steep, which is a verb, in a cup of coffee, I'm not sure how they can be so aggressive against that. If, for example, and you can correct me if I'm not following this, but in your instructions, so I go and buy your brand, which, by the way, I think you should start marketing to busy moms, not just camping. But if I go and buy your product and the instructions say, open the wrapper, put into a boiling cup of water, steep for 5 minutes, I'm not following how they could enforce that against you, because you're not doing anything other than using the verb in the sense of the verb. But what I'm guessing they're doing is trying to stop you from buying Google AdWords, perhaps, or doing any marketing that would say steeped. Maybe help me understand that a little bit more.
Yeah, so it was on our website, and they sent a really aggressive cease and desist, and it was descriptive, steep the coffee.
Did you get an attorney to write back to them, or is this pretty recent?
This was a while back, and we did go back and forth with them a little bit, but at the end of the day, we basically decided that it wasn't worth the legal fees just to like continue to deal with this guy.
And maybe it's not, and that's a decision that only you can make, and I respect that decision all day long. But that really seems like an unnecessary overreach on their part, because they are on the supplemental. It's you're using it in the proper verb sense. But you could also just ignore them and, focus on your brand and just say, kind of, go pound sand. We're going to be better than you because our mark isn't descriptive. You've got a few avenues. I don't know. I think that I wouldn't agree with their spot, but, people get really aggressive and want to carve out their space all day long.
Yeah. Yeah. This is one of those guys. So, all right. Yeah, this has been super helpful. I think I'm going to just continue not using the word because it's not worth the stress or the headache or the money to use that specific word. So, and
that's the safest bet. I mean, that's, you've clearly gone on a different path, and you're, you've got your own brand name. So I would just maybe focus on that and kind of let them go and, go from there.
Cool. Awesome. Thanks, Lindsay. I really appreciate it.
Happy to help.
Awesome. Thank you, Lindsay. That was a great insight. I was sitting here thinking like, wow, can someone really do that? Like, I steep my tea bags, And so you kind of think about the variations of the word and how they can actually try to box them out. You have something to say, Jonathan? You got an insight on this as well?
Yeah, I'm going to pretend to be smart here for a second. No, I'm just kidding. Lindsay, I had a question for you on the intent to use and then the use of commerce. If you are if you have the trademark out and your intent is to use commerce, but you actually haven't booked revenue as a result of that, what classifies as use of commerce? Is having a website where you have services up, but maybe you haven't transacted yet, does that count? Or do you have to actually book revenue first?
If services are available to the public for purchase, but they haven't purchased it. Ideally, you want that first purchase to happen because there are really two dates of first use that you have to provide. You have to provide the date of first use anywhere. So that would be the minute your website goes up, the minute, you offer it across state lines, for example, or, you're sort of putting it out there. And then there's the date of the first use in commerce, which means the sale is transacted. But if you've got a service that has an offering available, so somebody can go to your website, they could buy it, that's considered use in commerce. Whether or not they did isn't what we're looking for at the moment. It's that it was available for public to purchase.
Gotcha. Okay, thank you.
Good question. I'm pretty sure many others had that same question, Jonathan. So that was an awesome question. And I guess we'll move on. I believe that's Ali that's next.
Hi, this is Ali. Thank you.
Hi, how are you?
I'm doing well. Lindsay, I actually have an office action on one of my trademarks, and I've emailed your website. So hopefully I can offline work with you guys. It's funny how you mentioned that it depends on what the reviewer had for breakfast, but that's not what my question is. I have a hypothetical, and hopefully I can, and relate it to patents and get some insight. Hypothetically, if an employee has done 13 to 14 patents inside of a corporation, and they move out of that corporation into a startup, what types of is there anything that needs to be carefully managed by that startup and the new founder in managing patents that might be written going forward, even if they don't compete with the previous company, but maybe they were thought of during employment during that tenure. What are the things that that this hypothetical situation that person would need to be concerned about? Thank you.
Well, I'll take a stab at that hypothetically. With that in mind, oftentimes many companies have been formed from previous employees that were part of their R&D or inventors team. And so, as we know, most companies require you to sign in all things that is invented or concepts or created underneath their umbrella is the property thereof of the company. However, if and then you want to make sure that anyone that was part of a previous, say, company A, and they were a prolific inventor with company A, and they come to company B, you want to make sure that you have one language within your R&D or inventors team or within your company identifying such the same type of language in which your attorneys would foster, identifying that things that are created underneath this umbrella is and belong to the umbrella. However, where it can get sticky is if some of the proprietary information in company B was extracted from company A because of that inventor. And so you want to make sure that some of those lines are not crossed. You want to be import a stream of due diligence when it comes to developing your idea, just to reinforce and secure that concept that it was not a runoff from company A, and that company A doesn't have any proprietary patents and or concepts, ideas, published non-patent literature within your going forward ideas. So it's all about attempting to be as transparent as well as safeguarding and having a legal team kind of go through that model and make sure that you don't cross any lines, because I've been a witness of many companies who the prolific inventor left company A, went to company B, and started to invent. But however, some of the things that they were inventing were still proprietary to company A. And so therefore, company B was in lawsuits. And so it can be a very costly, sticky situation for startups, for large corporations to kind of go down that road. So you want to at least have that discussion with a commercial attorney or your business attorney and or your IP attorney in regards to that type of relationship, and make sure that all T's and I's are crossed and dotted. I hope
Thank you
I
very much.
addressed that.
That was very helpful. Is there any time frame that company B needs to worry about?
Yeah, it could be. It depends on the contract that, say, the prolific inventor, their relationship with company A. If he or she left company A in a volatile situation, that could maybe raise red flags, especially if company B is starting out with inventions that mirror or have any similarities. That could be problematic. So you want to make sure that anyone that's leaving company A and going to B is not still attached by a clause within their previous contract identifying that they are not permitted to work with competitors or something within that line of R&D or inventorship. So you just want to vet that as much as you can.
Thanks, Ms. Carter. That was I appreciate that. I'm done.
You're very welcome. Thank you so much. And I will move on to the next question. Would anybody else like to take a stab at that? Oh, did he disappear? Yeah, I think it's gone. Okay. I think it was a PTR. Okay, well, I'll keep it going. Let's see. Next, please say your name. I don't want to
I love
chop
hearing
and
you guys
screw
try
it.
them.
You just want to hear me try your name. I'm telling you, if you do not go to sushi takeout, I will just chop it up. I do not want to chop up your name. So please introduce yourself and your question to the panel. Thank you so much.
Thank you for having this. My name is Neriman Georges, and I just have a small company that I started last year, and I've just put in for a trademark. I did one just for Australia, and then I want to do one internationally. But I just had a quick question. I don't have an attorney. I've been doing this myself. When I've done my trademark, right now I've only added in like the fashion design section. As my company grows, if I have different, like I go into more of a lifestyle brand, am I able just to go into my trademark and add sections? I'm sorry if this is a dumb question, but I just could not find the answer, and I just didn't want to do the international trademark until I kind of knew if I could kind of go back and forth as it grows. Thank you.
A foreign trademark question. I love these. So you did it in Australia yourself, which is awesome. At the beginning of your question, I was going to ask when you filed, because there's a 6-month window of time to claim priority if you want to file an international application. But having said that, when you said that you wanted to expand, I would suggest filing a new application for all of the things that you want to do. So, it really depends kind of on the jurisdiction that you want to be in. Every jurisdiction has slightly different rules. Here in the US, you can obviously file with an intent to use. So as you grow, you'd be covered. You can also file piecemeal. So if you want to just do what you have now, and then you want to think about expanding into a lifestyle brand in a year, you could then file another application. But the root of the question is that you cannot add on to an existing application. Once it's filed, it's filed. Then you would need to file an additional application for additional coverage.
And when you file, so if I file again, I just file it again under my name. Like, how would that work? It wouldn't say that's already like there, I guess. Sorry if that's confusing.
Nope, it's not, because you're going to file in a different class. So I can't speak to Australian trademark law, but in the US, for example, if you were to file an application, say you filed one 6 months ago, and it was in your same name, and then you go to file one again in your same name, the examining attorneys, assuming that it's an identical name, address, email, everything, they'll associate them. So they will recognize that, hey, you're the owner of this other application. When it becomes a registration, then we actually note that on your application. So if you have a registration here in the US, you want to file again, there's a little box that says, applicant is claiming ownership of prior registrations, blah, blah, blah. And then you can add in all those numbers. And so that automatically associates them with you. Now, as you grow, you're probably going to assign your application from your name individually into your entity. That's typically how it's done here in the US. I don't know about in Australia, but so that would be something to keep in mind as well, as you do that, you would want to assign those rights over to go with the entity. So as your entity grows, and you hopefully would want to build up an empire and sell it off, all those rights go with the empire.
Thank you so much, Lindsay. That really, really helps. Just one more really quick question. Once I put a trademark in, is there an expiry or no?
Yes, there is. That's a good question. So every jurisdiction has a different timeline for how they calculate their expiration or their renewals. Again, trademarks can continue to get renewed once they become registrations forever. I don't know of any jurisdiction that you time out on your renewals. But once you get that registration, it should say, and I believe even in Australia, on your registration certificate, it even says the expiration date. Here in the US, you have some maintenance filings that are due at various points after registration. But my recollection of Australia is that you guys are pretty straightforward, and that I think it's every 10 years. And my brain is failing me on if it's from the date of application or the date of registration. But there is an expiration date. And even you guys have an amazing online database in Australia for trademarks. And I'm pretty confident that they actually tell you in that online database what that expiration date is.
Thank you so much. I appreciate it. Thank you.
Happy to help. Good luck.
That was awesome. Thank you, Lindsay.
I don't get to talk about foreign trademarks very often. That's kind of exciting for me.
Yes, I always wondered though about foreign trademarks. Are they the same? Is it the same process with patents that if you are from not a U.S. citizen, you would need to get a registered agent or a practicing attorney in order to file? Because I know for patents, you cannot file if you are not a U.S. citizen. You would need to have representation because, as we know, the Patent and Trademark Office is open. You can file yourself a patent application. You can file a trademark yourself. However, it's sometimes not recommended because the laws change often. Is it impossible? Absolutely not. Can you do it? You absolutely can. I do not tell anyone that they can't do it themselves because it is achievable. However, sometimes it requires craftiness. So I'm uncertain. I believe that with for non-citizens filing for trademark, they also have to have U.S. representation in doing so. I'm uncertain about the trademark portion.
They do. Yeah. So if you're not a U.S. citizen and you want to file a U.S. trademark application, you have to have U.S. counsel. When it comes to filing internationally, so if you file here in the U.S., you get your filing date, then you have a couple options with foreign filing. You can either file under something called the Madrid Protocol, or you can file directly in each country. Both paths have their advantages and disadvantages. With foreign filing for trademarks, which is slightly different than patents, if you file under the Madrid Protocol, you don't necessarily need to get local counsel in the jurisdiction in which you elect. So say you file an application in the US, you then go file an application under the Madrid Protocol, and you want to get protection in the EU, Australia, and Ireland. So you can go ahead and file that. It'll go to something called WIPO, the World Intellectual Property Organization, and they will then push it out to those local jurisdictions. If those local jurisdictions have no issue with your application as filed, you can just go ahead and get a grant of protection, which basically says, hey, your mark is acknowledged and registered in the country here, and you didn't need to engage any local counsel. If you get any sort of commentary back from that local jurisdiction, that's when you have to get local counsel. So it's slightly different on the patent side.
Awesome. Thank you. I'm pretty sure that was some good nuggets for someone in the audience. It was great nuggets for me. It just reinforced what I thought. I still was uncertain. So thank you so much for clarifying that and just making it very easy to understand. So we're going to move on to David. Hi, David. How can we help you today?
Hey, good evening, everyone. Really nice session here. Very helpful. Hey, I have a couple questions. One is, which one is a better filing, comparing filing by the company versus filing by the individual person in a startup setting?
Are you referring to trademarks, Pat, or
Trademark. I'm
patent
sorry. Yeah,
trademarks?
trademark. Yes.
Lindsay, that's you.
So that's one where I might have to pull that I'm not an attorney card. So with patents, it's the individual inventors then assign it over to the entity. With trademarks, that's really a decision that I don't know that I'm qualified to answer that one. I would say, like, for me personally, I filed my own trademark application myself in my own name, and then I assigned it over to my business, simply because if I ever have the good fortune to sell my business, build a startup and sell it, live the dream, then the trademark's going to go with it. So that's just kind of how it goes when you do that. Plus, if you're a bigger company, you want to be able to license out your trademarks, right? So if your company owns them, you can license them and generate some additional revenue streams for using that mark for maybe different avenues. Entertainment companies are really good about this. So they might release one product themselves, but then they're licensing out their marks to clothing designers or shoe designers or toy manufacturers. But all of those original trademark rights are held by the company themselves. Hopefully that helps. I know it's probably not one of my better answers, but hopefully that helped enough.
Well, thanks for the perspective. Second question, might be a little getting the detail, but if you feel like that's not a good question for this forum, that's okay. So I was looking at the trademark, and I'm just jumping on the details. One of the mark called Panda is in one of the category. Then I look at I basically search on Panda. That's the keyword in the same category. And then there's a flying panda. Then that one gets registered. And then there's another one called Dizzy Panda that was rejected. So they're all in the same category. So my understanding before seeing this one is if you have a noun like a panda, a keyword, then basically all this adjective plus noun probably would not be registered. Like Dizzy Panda, it get rejected. But I was really surprised to see the flying panda get registered. So what's the trick over there? And also in the same category, there might be sub category of the goose, right? So the goose may be, so the general category could be beverages, alcoholic beverages, and then the subcategory could be vodka, tequila, whatever the detailed types, right? Does that matter in terms of differentiating what gets passed, what gets rejected, what gets registered?
Yeah, so you can have so it depends is sort of the standard answer, but you can have the same or similar marks registered in different classes. Whenever I'm in these rooms, I always love to hear the examples that trademark attorneys give because there are a few out there. So Dove is one of them. You have Dove for soap. You have Dove for chocolate. You've got Delta. Delta Airlines is most likely probably not going to get confused with Delta faucets. I mean, if you're going to look at a faucet for your kitchen, you're not expecting to book a flight, to Washington, D.C. So those are kind of the two, that are the easiest, most recognizable ones. There are definitely others. So it really comes down to the classification of the products that are sold under the Panda name. So if you're selling battery cases, which is probably in class 9, you're probably not going to confuse them with vodka in class 32, I believe.
Sorry to interrupt. I probably didn't make my question clear. So when I look at that, when I search on Panda, all these marks I refer to are in the same category. They're in exactly the same category. So my question probably can be separated into two. One is in the same category, why Flying Panda gets approved, registered, and Dizzy Panda was rejected on the prior mark of Panda.
So that one may come down to the actual individual listing of services or goods, because these classes can be so broad. It is completely possible. Let's use class 41, for example. So class 41 is the class that you pick if you're selling educational workshops, but it's also the class you pick if you're a live entertainment act. So it is possible that with those marks in the same class, their service or good offerings could be so different that it's unlikely that a consumer is going to be confused by them. You know, if you're going to go see a stage show by the band Panda, you're probably not looking for an educational workshop on public speaking that might happen to fall in the same class. Does that help?
Yeah, I think that helped. That's probably could be the case over there. Yeah. Thank you. Appreciate that.
Of course.
Just to share one comment on the trademark, there's you alluded to that as well. There's a goods, marks on the goods and marks on the service. For the service, which I had one before, if I have the website up, that's considered you have the service up. So that wouldn't need the intent to use. But if it's some physical product you intend to sell, that need to file for intent to use.
Yes. Yeah. If it's a product that you're intending to sell, then you want to do an intent to use. And if it's a service and you don't have a website up, you're not offering it for sale, then that would be a service intent to use. But if there's a website, a client can find you, they could pick up the phone and book your services, then I would make the argument that the mark is in use.
Yeah, you're right. But the little trick is if you're trying to sell your service, the easy way to get it up is to put up a website, announce that, and that kind of, put a mark in use.
You're definitely putting the public on notice for sure.
Thank you. I'm down here. Thank you.
Awesome. Thank you. Great question. Thank you, Lindsay. Great answer as well. We're going to move on, and I would say, look, guys, my eyes are weak tonight. Thank you so much. Please introduce yourself to the panel and provide your question. Thank you so much.
Hi, thank you. My name is Marhan, and thank you for giving me the opportunity to get up and ask my question. My question is around patents, both a provisional patent and what that entails, and then really around the process itself from, the search process. Do you need to hire an attorney to conduct the search and then file for the provisional? Or I was told that since 96%, and I don't know if that number is even accurate, but that's what one attorney told me, 96% of all provisional patents are rejected. So it almost doesn't really matter if you invest the money to do the patent search first, as opposed to moving forward with a provisional patent. So hopefully I elaborated well with the question.
Yes, I think you did. Well, first off, I am not an attorney, so I always make that very clear. However, when it comes to the provisional patent, the provisional patent is like your date saver, right? And so it will become a business strategy for you and your team, and that's for anyone that's listening. When you're trying to decide whether or not to go forward with the patenting process, the purpose of the provisional patent is to provide applicants time to establish exactly what it is that they're specifically claiming to be their niche for that granted patent. And so the meat of the patent is more or less your descriptor, right? And so that is your provisional application. The provisional application is usually like your first stop. And so it's not shown to the public. However, what everyone fails to understand also is with the non-provisional patent, the minute you start the process, it is open to the public. It is published. It is actually now your competitors can see it. Everyone can see what your intent is at that moment. And so it becomes a strategy, whether or not it's better to kind of just save the date and start the process because the provisional patent is not shown to the public, whereas the non-provisional patent is. It's immediately published. And so that's a strategy, for instance. And when it comes to 95% of the patents are rejected, I don't necessarily believe that. I was a previous patent examiner, and that's just not the case always. What the problem is, or what that comment may come from, is an area of saturation, and that is where the rejections are bred from. The rejections from a patent examiner standpoint, and I'm speaking from my previous experiences, are bred from knowing these prior arts or knowing these concepts or ideas within the public market space, on non-patent literatures and journals and dissertations, in seminars, symposiums. Any form of public information is what typically causes and always causes the rejection process. The one thing is we cannot reinvent the wheel. And so in some cases, there may be that one spark of new nuance of a technology that it hasn't been seen and hasn't been heard. But once that began the patenting process, then there are modifications thereof that follow suit. And so everything that follows underneath that umbrella in regards to that concept or idea is now fair game to be used in the examining process. And so, as I stated before, the key to it is really being strong in your due diligence and identifying your key competitors and whether or not your concept or idea already exists. And if and then it does exist, then you can come back and say, okay, well, this aspect of it exists. So what do we do from here? Many inventors, companies, they have choices. One choice could be, well, I'm going to utilize a patent attorney and IP professional or a practitioner that is an expert as far as their background. Many patent attorneys and IP practitioners have a multitude of backgrounds. And so you want to make sure you have one that is within your background. For instance, my background is electrical engineering, physics, as well as biomedical with emphasis on neuroscience. So that gives you a breadth of where my expertise of my technical knowledge will land. And so that is how you would sort after your IP professional, your patent attorney in that perspective. And so you would either go that route and have them do a very exclusive or in-depth search or give you an opinion whether or not your concept is patentable based on what may be already out there or not. Some will go to the route of a company similar to mine, which we specialize in providing competitor market analysis and patent landscape to give the inventor an idea of where his patent sits within the space, and so that they can make great strategies moving forward in how and what they think they might be able to get as a patent. And so it's really comes down to an executive decision, but I would not use the percentage of rejection as a means to choosing one of the other. I would use strategy as a means of choosing which direction to go.
Thank you so much. This has been extremely helpful. And I definitely followed you. So, maybe I can connect with you after. I'll DM you.
Oh, absolutely. I am free to communicate with you or anyone else that is just curious, that may have that same question, because really your question, your comment was spot on. That is a constant perception that is provided, that, oh, they're rejected anyway. And so that is the Patent and Trademark Office doing their due diligence to make sure that you don't infringe on someone else's proprietary idea, concept, or product, and you will want that same service done for your idea, concept, or product. So it is a thorough search that takes place when it comes to the examining process. In all literature and open forum information is taken in consideration. So being very strategic in your goals with your R&D and your research team or any of your executive board when deciding whether or not patenting is your way to go. It is not the only way to go, but it is definitely a way of protecting and enforcing your rights when it comes to your proprietary idea. Some actual choose not to go through the patenting process, as we had stated earlier, because it is public. It becomes public. So if you have something that I can look at your patent and actually replicate it, then some companies have a fear that if they do go the patent process, then their whole toolbox is available to the public, which in some cases it is. So that too is a strategy that your patent attorney, IP practitioner, and when I say IP practitioner, you have the ability of choosing an IP or a patent attorney of choice, as well as a patent agent. And one particular IP attorney that is great at what she does, she's late for the panel, but she's awesome, and that is Miss Sheila. Hi, Sheila. How are you? Had a great question, and we missed you earlier, but you're here now.
Hey, how are you? So sorry, I was caught up on calls all day.
I understand, super busy. I'm going to pause for a moment. I was just spinning out, answering a question, but I would love for you to introduce yourself to the audience, and I'm going to mute my mic. Oh, Sheila, are you there?
Okay, can you hear me now?
Yeah, now I can hear you. Wonderful.
Oh, so sorry. Yes, so I'm Sheila Gibson. I am a patent and trademark attorney, and I spent, so my technical background, agriculture companies
Oh, I'm
protect.
sorry. I'm sorry, Sheila. We lost you. We couldn't
Oh,
hear
no.
anything.
It was all so good. Anyhow, I'll just keep it super short. Can you hear me now?
Absolutely.
Okay. Yes. So I spent my first 16 years in big law helping biotech, clean tech, medical device, and agriculture companies protect their intellectual property. And in 2019, I started my own law firm specifically to also help the cannabis industry protect intellectual property. And so being a founder myself, I actually work with a lot of founders and startups, and am also, very understanding of the startup position, now living the startup life myself. So happy to be here and help, and love spending my Tuesday evenings with these two wonderful ladies.
Oh, you're going to make me blush. What about you, Lindsay? You're blushing over there.
I'm just honored that I can be in the present. So we're good. But look at this, right? Like the three of us running the show.
You're right. I love
They let the
it.
inmates run the asylum.
Yes, they did. Watch out, audience, because here we come. But this is awesome. I love it. Everyone, we'll just reset the room. I have not done this at all since I've been just talking. We love to talk IP patents, trademarks. As you can see, this panel is awesome. We're here under the founder stream every Tuesday at 8 p.m. to typical 10 p.m., and that is Eastern Standard Time. We often have a host of a multitude of attorneys on board, on stage, as well as myself, Lindsay, Jonathan, and so forth. So if you did not, or you're just catching the tail end, we typically close out about 10. Sometimes we run over, but we'll always be here every Tuesday under the founder stream at 8 p.m. So we'll keep it moving. However, I want to make sure, was there any other question you may have?
Yeah, can I ask a follow-up question on the previous question that asked by the lady about the provisional patent?
Absolutely.
Yeah, so if I take a entrepreneur's perspective, right, on the value of the provisional patent, the way I see it is, one is, like you mentioned earlier, to establish a priority date so that, any relevant inventions will I'll take the priority over there. The second value I see is if I get a good attorney, they can help draft the claims, which is really the sort of the value of the property claim on the value of the patent. So as an entrepreneur, I may not know how to draft it well, but I don't see much value in terms of doing the patent search, because I have a full year to actually do the patent. I mean, to implement the invention. Eventually, if I get a patent or not, when the non-provisional was filed, when a non-provisional filed in the future, the patent office will do the thorough search as well. So economic-wise, I probably pay the same money for the patent filing fee, which included searching by the USPTO, versus if I pay a law firm, I probably end up paying more. I don't know if my perspective is correct, or if there's some holes in it that I don't realize. I appreciate if you have provide some perspective on that. Thank you.
Ms. Carter, do you want to take this?
Well, actually, I'll let you take that, Sheila, if you don't mind.
Okay, sure. So you raise a really good point, and you're exactly right that the USPTO is going to do a search. The difference between doing it ahead of time and relying on the USPTO is, when your attorney does the search, we can then draft your application with those results in mind. So in other words, we're trying to figure out what an examiner is going to cite against us, and be prepared and have fallback positions in our application, so that if and when that does happen, we have a strategy for amending our claims in order to overcome the prior part.
Oh, I think you went out again, Sheila. Well, exactly what she was saying. I think Sheila will be right back in, and I will finish exactly what Sheila was explaining. The key is that strategy is being able, the purpose of the search, and being able to do a search prior to. Oh, there you go. Wait a minute. Are you there, Sheila?
I think my network is really struggling.
Yeah, now you were clear, and you might hear my grandbaby in the background, ladies and gentlemen. But I'll continue though,
Well,
if you want.
Well, I have a signal right now, so I'll just say I'll be shorter winded. So what I was saying when nobody could hear me is that if you wait and have the examiner search, here it goes with the poor network again. What you have to do is you can amend your claims in response to a prior art reference that the examiner cites against you. But you can only amend your claims based on what's in your specification. If you haven't run a search prior to try and figure out what the prior art is and build those fallback positions into your application, then you won't be able to amend your claims because you won't have the right fallback positions that you need in order to do so. And that's why it's really important to run the search and have your attorney draft the application with those search results in mind so that we can build in the fallback positions we might need to amend our claims in view of what the examiner finds.
Absolutely, David. She's spot on. I couldn't have said it any better. I hope Sheila answered your question. But that is dead and spot on. The purpose is to benefit you, to show the key to it is always, as a previous examiner, I always appreciated my applicants that were transparent and at least performed a very crafty search. And their attorneys typically made it very clear that, hey, we searched this space. We're the only ones in it because of XYZ. That assists the examining process. But then when it's not to say that the office won't search, because it's a requirement that all examiners search and do an extreme thorough search on any application that comes before the office. And also it is the applicant's due diligence also to perform a search, or at least be aware going forward. And also it's a great awareness for the inventor, because knowing what is already out there kind of helps guide and assist, as Sheila said, with developing the application and being able to try to give you claim language that is supportive and broad enough for whatever your company goal is in mind.
Yeah, that's very helpful. That's really the value is. I do see the point. To follow up on that, just kind of curious, how much would be the level of fee we're talking about to have a attorney to do the search and draft a claim to sort of kind of to get a better application, better provisional application, so that the inventions better carved out.
Well, I would say that it's no set fee. All attorneys are their own sounding board, if you will. Attorneys work in several different, they could have flat fee, they could have a variation of fee, pricing, as you will, in regards to how they go about it. So it's more or less, the key would be more or less finding that particular practitioner, IP professional, and then finding out what their fees is, because it's nothing standard across the board, if you will. If Sheila is available to chime in, maybe she could share what her ranges are, but typically it is a variation. Sorry about the little munchkin in the background.
That's all right. It sounds like she has some word to say as well.
Yeah, she does. She loves patents, and so I'm
Yeah, it
grooming
also
her to
depends
be
on
a
the
patent attorney. Go ahead. Yes, Sheila, please just chime in. Definitely chime in with that.
Okay, it sounds like she may have some challenges on the connection. I'm going to just throw out another question. If she can hear that, and she may come back and answer both at the same time. So I look at the patent, and I checked a little on the patent laws myself, and I look at the big companies like internet companies in particular, like Facebook, LinkedIn, even Google. Well, not Google, not count, but the social media companies, Facebook, LinkedIn, Instagram, even here, Clubhouse, right? So are these companies, the internet companies, social media companies, can anything that they have, the technology or the way they conducted the business model or business method or the platform, can anything be patented to create entry barrier here? Just kind of curious. Thank you.
Based on my search of that particular, most importantly, those companies, as you indicated, are pretty crafty. They strategize early in to take those things in consideration. So 9 times out of 10, they have a fence. And they've looked at every particular embodiment or aspect in which their initial filing could go. So I'm uncertain without a search whether or not there is room, but I'm pretty sure that the room would still be based on some form of licensing agreement on their perspective or something in that nature. But a search, that's the only way you would be able to kind of determine that per se. But they are very crafty. If you think about Google, in the database alone, Google has over 30,000 patent families, and all built around their search engine and the capabilities of that search engine. So it varies. It varies tremendously. So I hope I answered that. And if anyone else would like to chime in, that would be great. But typically they create huge and very smart and what we call a fence. And they take all of the different aspects of the invention into consideration. And so they typically have patents on it.
Thank you very much. Appreciate that insight.
Wonderful.
I just had a follow-up question regarding what you were saying with the patent that would be public for all to see. Did you say that would be the provisional patent, or once the patent is approved, it becomes public?
I'm sorry, I thought I pressed the button. The provisional patent is kind of the early filing date. So that establishes your first to file, right? That is not available for public sites. However, the non-provisional, which is what most do file, it is published at the time of the application. So that is open to the public.
So I guess then a follow-up question: what would make someone file? What would be the reason someone would file a provisional versus non-provisional? What would be the benefits of doing a non-provisional?
One of the major benefits of the non-provisional is the date. Over time, I forgot when the first to file was formally established, but the purpose is sometimes, and just to give you an example, if you're in the midst of, say, creating a software or an app, and you have some model features you're still uncertain about, but the framework and pretty much everything is set in stone except for you're uncertain about other aspects of your concept or idea, you want to be the first to file. You want to have that first date. And so many use that first date, that first to file, that provisional patent as their save the date while they continue to research, while they continue to maybe tweak or modify things. And it may be a strategic move on their part to be able to file other things. It just depends on what the executive decision is, but it's always a great benefit because you initially get that date, and especially with software, sometimes it's not fully built out, but your concept or your idea is, and so you want to safeguard that. And so that's typically the purpose of it.
Okay, but that would be for the provisional patent.
Yes,
yes. But the non-provisional is the one that would be public.
Yes, you
so
only
what would
have
be the
1
benefit of
year.
filing one that's public?
Oh no, that's the only one.
Oh,
the
okay.
provisional, yes, the provisional patent is only a preliminary patent, and it's more or less to give you an opportunity to be first to file. However, you do not need to or have to go that route. You can go straight to a non-provisional and be ready to rock and roll. And so it's more or less a strategy purpose, a strategic measure for many. And the non-provisional patent is really what a patent is. It's your utility patent.
Okay. Thank you. That makes a lot more sense. I appreciate it.
No problem.
I just wanted to add in one thing on the patent
yes.
side. The provisional application doesn't actually get reviewed. So it's literally just a placeholder.
Yes.
So it's basically your ability, once you file that provisional patent, you can start to develop your product. You can go create your prototype, even market the business in that time frame until and your idea is protected. Would you say that's accurate or no?
I am a little yes, a little no. I don't know if Sheila is available. There you go. Wonderful. Are you available, Sheila?
Every time I try, my signal goes out.
Because I don't want to give any legal advice. I leave that all up to you or legal opinion in that perspective.
Oh
did
yeah,
you hear
I'm not
the
giving
question?
legal advice either. But no. So yeah, you have the right idea. So provisional patent, you don't have to wait for your prototype. So it's definitely something you can file. One thing that it is a benefit if you file before you start working on your prototype, especially if you're going to start working with other people. I would say when you get to the point that you're going to start talking to other people, whether it's investors, manufacturers, whoever's going to help you with your prototype, whoever's going to help you reduce your invention to practice, that's probably the point where you should start thinking about a provisional application.
I'm sorry, Sheila, you cut out again.
I think she's gone again. But
wait, I think she's back on because maybe not.
But she's not back on. But yeah, it gives you time to work on your product and massage everything and get your marketing and so forth out there. It holds a lot of benefits. And it's really strategy, and it's a strategic move that many companies do actually. And so I was hoping she would finish that for you, but maybe she'll chime back in and we'll come back to you for that. I wanted to hear her last snippet of what she was saying. Okay, sorry. Well, Miriam, we'll come back to you and finish that.
Yeah, no problem. Yeah, please continue.
Sheila will be back, and we'll move to Kay. Hi, Kay. How are you? Thank you for joining the Founder Stream. And how can we help you?
Good evening. Thanks for having me. I really appreciate this room. I have two questions for you in regards to trademarks. So I wanted to find out, after one receives the confirmation of the trademark approval, is there specific evidence of use that we need to have ready to submit for the renewal process? And secondly, is it mandatory for us to use the R trademark sign when posting content online and on labels?
Okay, so let's start with your first question. So when you mean you got notice of approval, does that mean that you have a certificate of registration?
Yes.
Okay, perfect. So, so between years 5 and 6 after the registration date, then you're going to file something called a declaration, a combined statement. What's the official word? Declaration of use and incontestability, I think is what it's called. I just call it a section 8 and 15. And so that is when you file a specimen showing that your mark is in use and you are declaring that your mark is in use for all of the items and for which it was originally registered. So if your registration has 35 items in it and you're only selling 15 of them, then you would need to remove the other 15 that you're not selling. And to prove that, you could submit website screenshots, photographs of the product. If distributors are selling it, you could show where it's sold on their website. So there's a lot of different things depending on what the registration is for. But it's similar to filing a statement of use that you probably had to file, or if the mark or if the product or service was already in use when you initially filed, it'd be along those same lines. And you have a year to complete that. So you'll get an email from the USPTO at the year 5 anniversary, and then you'll have 12 months to complete the filing. And right now, I think that filing costs $425 plus fees if you have an attorney handle it rather than doing it yourself. So that's that part. Your second question, I really wish that Sheila had a signal because it's definitely one that is an attorney question for sure, whether or not you should use the Circle R. What I would say is from the USPTO website directly, it is not mandatory to use the Circle R. It is highly recommended. So that's what I would say on that one. That's kind of a tricky one for me to answer.
Okay, thank you so much. I was just wondering about, the Circle R because, I mean, it's good to put people on notice that, hey, this is registered and things of that sort, but, sometimes you don't want everybody in your business necessarily.
Well, really what the Circle R is doing is putting the consuming public on notice that your brand is protected. So you're saying to external parties, hey, this is a registered trademark. Don't go use it, basically. Now, the creatives don't always love the Circle R because, it can jive with or doesn't jive with the way that they design logos. I get it. But the reality is that it does serve a purpose, and that's to put the consuming public on notice that you do have a registered trademark.
Okay, thank you so much. I really appreciate it.
Can you hear me?
Now we
Yes,
can
ma'am.
for 30 seconds
I don't know
or 5
how
seconds.
long, right, my signal will last, but you don't have to put the Circle R in every instance. So I would go
Every time, seriously.
if you can hear me. I would go with something that's aesthetically pleasing. So maybe in some instances where you have written text, put it in, but maybe not in every single instance because that's a little.
I feel like maybe it's not meant to be.
Yeah.
Right. But I'm so excited because these questions are awesome. But I would say another thing you could do is you can also put a paragraph on your website or somewhere where the mark is used that says that such and such mark is a registered trademark of the entity that owns it. But I would at least kind of sprinkle it maybe in 1 or 2 places, but you don't have to use it everywhere. The one thing in terms of legal requirements, it's illegal to use it if you don't have a registered trademark. So if your trademark ever lapses, even though if it was once a registered trademark, you do need to remove the Circle R. But in terms of, is it are you required to use it? I don't know that there's necessarily a requirement, but I think, it could be a problem if people start using it and they weren't put on notice that it is a registered trademark.
Okay, and another question came to mind as you were speaking. So when you say website, right, is social media included as a website, or are you speaking of just, your separate website that you purchase a domain for?
Yeah, social media is included. If you wanted to put a little disclaimer at the bottom of your post that said such and such is a registered trademark of your entity, or if you wanted to sort of just sprinkle that circle R emoji, one place in the text, or even just at the top, if that's not aesthetically displeasing. Those are maybe some ideas, but I would want to mark it at least in a couple places.
Okay, excellent. Thank you so much, guys. I appreciate it. I'll move myself back to the audience. Have a good night.
Thank you. You have a good night too. I love your voice. It's just so mellow. I'm working on my mellow, but I don't have it. I'm super hyper. Okay, guys, we're at the 10 o'clock mark, and I'm doing an all call for any remaining questions, or I will cut off the hand raising. So if you do have a question, please just raise your hand. We'll pull you up. Outside of that, I'll move on to Terry. Hi, how are you?
I am well, thank you. Good night, ladies. Thank you so much for this space. I have a question. So I make natural skincare products, and I was speaking with a manufacturer, and I sent over my NDA, and when they sent me theirs back, I was reading it, and I realized that in it had mentioned that they would own my formulation up to $250,000 for each product. I have 4 products, and they will release it after I meet that criteria for each product. And I was just wondering if that is standard industry practice or or not.
Wow, I'm so glad that you read that. I can't tell you how many people sign those and don't read them. There's definitely not an industry standard. Every agreement that you come across in everything in life is written either specifically for that entity or person or situation, or it was borrowed and doesn't really apply. So it's definitely, I don't know how much, because I can see that my network is bad again, but there's definitely not an industry standard that was drafted for them, or they're using it and they don't realize that it's in there. And so it's definitely something that you should negotiate. And, first I would negotiate to remove it. And if not, at least negotiate it to something that that is workable for you, or that makes sense for your business.
Okay, thank you so much, because I did bring it up to them, and she said yes, that is it, and they're not willing to negotiate. I think they are used to people not seeing it, but I read through everything, and I'm still pretty new to business, but I thought that was a bit outrageous, because my products are not white label, so, and I created my formulations, and so I was just a little bit concerned about that. And I happened to be in another room, because I'm still very new to entrepreneurship and just very green, but I heard them mention IPs.